Welcome to Just Us on Spreaker. Just Us is a self-funded, not-for-profit grassroots organization of advocates who see the problems in the ever-eroding criminal justice system. Our mission is to raise awareness and encourage others to take a stand and put justice back into the justice system. A single advocate, a single voice is where change begins, but together our voices can change the world. So thank you for joining us. With an estimated 120,000 plus innocent people in U.S. prisons, it has never been more critical that we all stand for change. To date, there have been 2,601 innocent people exonerated, who collectively lost 23,000 years of life. While this sounds encouraging, it is merely a scratch of the surface. To quote Human Rights Watch Prison Project, in many jails, prisons, immigration detention centers, and juvenile detention facilities, confined individuals suffered from physical mistreatment, excessive disciplinary sanctions, barely tolerable physical conditions, and inadequate medical and mental health care. Unfortunately, there was little support from politicians or the public for reform. Usually in our periodic broadcast, we talk about issues surrounding our broken criminal justice system. We discuss things such as people with cognitive and intellectual disabilities in the justice system, mandatory minimum sentencing, which takes the power out of the hands of a judge and hands it directly to a prosecutor, destroying judicial scrutiny. We discuss corrupt laws, felony murder, wrongful convictions, prosecutorial and judicial misconduct, the overreach of prosecutors, the go-around that police use for Miranda, all of which feeds the mass incarceration, and more. The United States is called the incarceration nation. We currently have a population of 331,002,651, roughly 4.4% of the world's population, yet we have 24.7% of the world's 9.8 million prisoners. In the freest country in the world, 2.3 million men, women, and children. We've allowed our broken system to execute the innocent and then later find that their claims of innocence were true. We can't take that back. But we can rebuild our justice system. We can rid the system of corrupt players, and we can abolish the laws that breed corruption. Thomas Jefferson once said, "When injustice becomes law, resistance becomes duty." We live in a time where 95% of all state cases and 97% of all federal cases end in a plea deal. This is a plea bargain epidemic. According to the U.S. Department of Justice, 64% of local jail inmates, 56% of state prisoners, and 45% of federal prisoners have symptoms of serious mental illness. People with intellectual and cognitive disabilities represent over 10% of the prison population. African Americans represent only 12 to 13% of the U.S. population, but make up 37% of prison inmates. With these statistics, we have to call these groups what they are: target groups. The bottom line is that if we do not take a stand and reverse direction now, we will have allowed the carpet to be pulled out from under future generations yet unborn. We need major reforms today. Ask yourself, how many wrongful convictions are acceptable? How many innocent lives destroyed by the justice system are you comfortable with? That change begins with you. The French philosopher Montesquieu once said, "There is no greater tyranny than that which is perpetrated under the shield of the law and in the name of justice." Stay with us. Our guest speaker tonight is Emelia O'Brien. Her husband is Sean O'Brien, and you can see his story on our website, www.just-us-justice.com, and look under Stories. The felony murder law has taken many innocent people and destroyed their lives. An old draconian law that seeks not justice, but maximizes on easy convictions, requiring little to no culpability, and carries with it harsh mandatory minimum sentences. Supreme Court Justice Sonia Sotomayor said it best. A statute that shields itself from judicial scrutiny of sentences of life without the possibility of parole raises serious constitutional concerns. Sean Allen O'Brien was wrongfully convicted in adult court at age 16 and sentenced to life without the possibility of parole, plus 10 years. He spent over half his life incarcerated for a crime he had no involvement with. Today he is 34 years old and is still waiting for justice. Tonight, Emelia will share the rest of the story, so please stay tuned.
Thank you for joining us. So as Eric told you, we will be talking with Emelia O'Brien this evening regarding her husband Sean's case. And first thing I want to point out is we, like most of the rest of the world, are operating remotely. We are not sitting in a studio. So we do experience the occasional technical difficulty or a noise bomb that goes off, cat meowing in the background, dog barking. So bear with us, it's the message that counts. So I just want to give you a brief rundown of Sean's case, and then we will bring Emelia in and she can tell us the rest of it. So with Sean, on February 26, 2003, a gentleman named Kyle Smelser was killed during an alleged burglary. Afterward, one of the victim's neighbors told the police that they had seen a green truck and a white car on the day of the murder. Upon hearing this, another man who knew the victim's roommates and also knew Sean from his place of business reported that Sean O'Brien's mom drove a green suburban type vehicle. Doesn't really fit the description of a green truck. Her vehicle, however, had been at her place of business the entire day. The green truck and the white car lead was never investigated further. Based on this man's statements to the police began telling people that they were looking for Sean. Being completely unaware of a burglary or a murder, Sean had gone to boarding school in Oregon, where police would later contact him. Without reading Sean his Miranda rights or having parental consent, Sean was questioned, and I'm sure was questioned using the Reed technique. He had no parent with him, he had no attorney, and he was voluntarily speaking to the police. Meanwhile, back home, this rumor that the police were looking for him continued to spread, and this opened the door for two older boys who did not know Sean to begin accusing him of burglary that had led to Mr. Smelser's murder. Both boys confessed to this burglary, but they placed all the blame on Sean, whom they had never met. Even though their stories were inconsistent and there was no physical evidence connecting Sean to this crime, and Sean had a solid alibi, he was still charged with felony murder. The two other boys continued to change their stories throughout the course of these trials, including the timeline and the details, but Sean was convicted regardless. There's so much more to this case, and tonight, Emelia, his wife, is going to talk us through what has happened to Sean and where he is now in his fight for justice. So welcome, Emelia.
Thank you so much for having me.
You're very welcome. So I want to go through the timeline of this injustice, if we could, for the listeners that aren't yet familiar with Sean's case beyond what I just relayed. So we know he wasn't present when the crime was committed, and there are people who could verify that. So what exactly happened that day that he managed to get dragged into this?
So that's a great question. It's a very complicated case, and there's a lot of moving parts and details. So I'll just go over them kind of slowly so that everybody can hear them and we can start to make sense of this. So Sean's name initially only came up because of the neighbor, Royce Clayton, who had said that there was a car that day and that Sean O'Brien's mom drove a green suburban type vehicle. That was the only reason his name ever got brought up. There was a gentleman by the name of Eric Wellman, who was aged 20 at the time, and Tyler Dixon, who was aged 17 at the time. They admitted to committing this crime. What they allege is that they went with Sean to this crime. Now we know that Tyler Dixon went to school at 8 o'clock and left 13 minutes later. That was never really brought up, and we don't know why he went to school and he left. So that morning, J.D. Petty was a gentleman who was at school, clocked in at school at 7:55 a.m. and he tries to allege that he was the one to loan Sean his shotgun to go skeet shooting, and says that he had no idea what it was going to be used for, and alleges that he called Sean at 7:55 a.m. But we know that J.D. Petty was in school at 7:55 a.m., which completely discredits his testimony that he had called Sean at 7:55 a.m. to arrange for the gun to be picked up. His high school administration testified at trial that he was indeed at school that day, and he had clocked in at 7:55 at school.
Now, this kid doesn't even know Sean, right?
He does, I believe. I'm not exactly sure how their relationship was, except for that he claims to have loaned Sean the shotgun. So I'm not sure if they were, I think they were acquaintances probably. I think Sean did know J.D. Petty, but I'm not exactly sure of the extent of the relationship. They did not go to the same school. And J.D. Petty claims to have gone and picked up the shotgun later on that day, but his testimony was completely discredited by being his work schedule and other people who were at Sean's house that afternoon. So they already had pointed out that his initial testimony and his trial testimony was completely false, but it was never brought up by the prosecution, and then it was never brought up by Sean's trial lawyer that, hey, this J.D. Petty guy, he lied about picking up the gun, and so therefore he also lied about dropping off the gun to Sean when he was at school at 7:55 a.m. And they actually had his high school administration testifying, but Sean's lawyer just did not pick up on that. So he didn't point out the fact that this kid was at school at 7:55 a.m. He could not have called Sean to drop off a shotgun. It couldn't have happened. So Sean's lawyer just completely at trial failed to present that. So the details and the timelines, according to who you're talking to, vary greatly between the initial statements they gave to the police and their trial testimony. So it's kind of hard to get an actual grasp on what really happened. But this is what they allege is the original timeline that they gave for the crime at the beginning of the investigation was from 11 a.m. to 1 p.m. The gentleman went to the Big Horn Gun Shop, which is an ammo and weapons shop in Placerville, California, and they bought shotgun shells. They were the first ones in the door, according to the trial transcripts, and the gentleman who worked there came to the trial and testified that these three gentlemen were the first ones in the door. There were no cameras that were operating or up at the Bighorn Gun Shop, so there's no surveillance at this time. Back in 2003, before it became really widely used, so there's nothing to go off of to base this on except for the testimony of the Bighorn Gun Shop employee, who said that three gentlemen, young gentlemen, entered the door. They were the first ones in the door, and around 10 a.m. is when they opened. So it had to be around 10 a.m. is when the three came into the shop. He could not identify any of them. So he was given pictures, he was given a lineup, and he never could pinpoint who was in the store that day. But he knew it was three young men. My question is, why were they buying shotgun shells if they planned to just commit a robbery with no one home? The discussion between the three men was to go and commit a burglary, specifically just a burglary. They wanted to, according to Wellman, they wanted to steal guns, they wanted to steal money, and they wanted to steal dirt bikes. And there was weed involved. So if they're going to commit a burglary, the first place they stop is the Bighorn Gun Shop to buy shotgun casings. I just find that a little odd. Wellman was the only one who was an actual adult, so he's the one who purchased the shotgun casings. He was 20. Tyler was 17, and we don't know the third person, but they claim it was Sean. So Wellman was the one who bought the shotgun shells. So they went to the place of the crime, which was on Treasure Lane, and shot Kyle Smelser. Now, the cops never investigated a boy by the name of Sean Santilio, who was also named Sean. He rode dirt bikes with his older brother, with Kyle, the victim, and his roommate. So they were friends. And he testified at the trial that William Wellman and Tyler Dixon had come to his house that morning to ask him to be part of this crime, to be part of the robbery with them. And Sean Santilio says that he chose not to, and that he declined this invitation, so to speak. Now, if they had come to his house and asked him to be part of this robbery, there were only 3 seats in William Wellman's truck. So if they had Sean with them, they would not have had a seat for Sean Santilio.
Right.
So that is very odd that they would come to this boy's house, ask him to commit a crime. He said no, but that only points to the investigation, and they never investigated this. They never interviewed him. They never interrogated. The cops only spoke with him 9 months later. He had 3 alibis. The first 2 were proven to be completely false. He was not even enrolled in school at the time. And so the first time he said that he was in school that day, and that was false. So the cops didn't investigate this whole other theory of Sean Santilio being involved at all. They only investigated, Sean O'Brien. They never investigated.
And the other Sean, did they both know the victim?
Sean O'Brien did not know the victim. Sean Santilio rode dirt bikes with his older brother Kyle. His older brother Jesse, Kyle the victim, and the roommate of the victim. So all 4 of them were friends, rode dirt bikes together, knew each other apparently. And we did not find this out until quite some time later, but the cops didn't come to him and speak to him until 9 months after the crime had already taken place. And they just accepted his alibi, did not investigate it,
which kept changing.
Right. The first 2 alibis that he gave them didn't check out. And the last one, they just went ahead and took it as fact, and they went on their way. They didn't ever investigate the possibility that Sean Santilio could have been involved. So these 3 gentlemen. I've only been listening to your story for a few minutes, and that's where my mind goes. Yeah, it's quite alarming. The cops really had tunnel vision, and the investigators on this case, they really were just focused on getting a conviction from Sean O'Brien. They completely had a lack of disregard for the law here. They didn't really do a proper investigation. They just went off the alleged confessions of these 2 men who admitted to being at the crime, and they had really nothing to base their suspicions on other than this testimony from these 2 gentlemen. So according to Wellman, when they arrived at the place of the crime where they were going to commit this burglary, there was a truck outside, and that didn't cause them to pause or leave or question what they were doing. There could have been somebody home, and they chose to enter the residence anyways. So that leads me to question, why did they enter this place when there could have been somebody home? And it was the victim. And so they come to this place to rob it, and then they find the truck outside. So after the fact, Wellman and Dixon couldn't tell detectives where Sean O'Brien's house was, and they couldn't describe the route they had driven to go there. So they had said that they had went and picked him up, that they had all driven to the crime together, and that they had driven him back. It was Wellman's truck, but they couldn't tell detectives where Sean's house was or the route they had driven. So that's very strange. That's not something that was investigated or really brought up.
I'm wondering why. Well, I mean, I could see why these boys would want to implicate Sean O'Brien rather than their friend.
Right.
But yeah, I'm left kind of wondering with you how they could ignore such obvious
Mm-hmm.
connection to this other individual named Sean when he was very familiar with the victim.
So William Wellman, he was actually, when he was initially arrested, he was facing the death penalty and they were naming him as the shooter. So he took a plea deal to get a reduced sentence. And the deal was that he had to implicate Sean and get Sean convicted and that he would get a lesser sentence himself. So I believe that is why he was willing to completely change his whole story and base it on Sean. We know that the investigators went into the interrogation with the statement, okay, we know the shooter is Sean, go from there. So it wasn't, it wasn't focused on finding the actual perpetrator. It was, okay, we know who did it, now go from there and tell us what happened.
Right, and that happens all too often. An investigation gets built around a theory rather than the investigation producing the theory. Once they've been given, the DA usually is who does it, says, this is what I think happened, this is what I want you to prove. That's the path the investigation goes down, while completely ignoring what really happened.
Right, exactly. The prosecution's own evidence, their own theory, proved that Sean was home the entire morning making calls from a phone, from his landline phone. The prosecution's own evidence proved that Sean was home until at least 10:30 a.m. There was a 10:11 a.m. call. There was a 10:30 a.m. call, an 11:25 a.m. call, an 11:28 a.m. call, an 11:31 a.m. call, an 11:32 a.m. call, an 11:44 a.m. call, and an 11:47 a.m. call. And from about noon on, Sean's sister Amanda and her daughter Madison and Cliff Sargent were at Sean's house. So he had a rock solid alibi for the afternoon. So we believe that is why they went ahead and changed the times, was because Sean had a rock solid alibi for the afternoon. And in the morning, the prosecution shows that he was home all morning because of these phone calls. So the prosecution's own evidence, they drove 4 different routes from Sean's house to the crime. They drove 4 different routes and they came up with 4 different drive times. They came up with 36 minutes, 39 minutes, 41 minutes, and 47 minutes. And Joe Alexander, the prosecutor, his solid statement to the court was that the crime could have been committed in as little as 36 minutes. But this is proven completely incorrect because the shortest drive time alone is 36 minutes. And when you have all of these calls placing Sean at home in the morning, and the 3 gentlemen who went to the Bighorn gun shop were the first ones in the door at 10 a.m., and the prosecution's own evidence proves that Sean was home until at least 10:30 a.m., there's no way that he could have been with those 3 men going to the Bighorn gun shop. And it completely renders his, the crime could have been committed in as little as 36 minutes. It renders it completely a lie.
It seemed like even if he had left right then, drove 36 minutes, committed a crime, and then got back in time to have an alibi for the afternoon, that's not even logical.
Right. So the prosecution's own evidence places all of that. Sean was home until at least 10:30. They have all these phone calls, and their drive times alone render it completely impossible. But that was never brought up. Sean's trial lawyer didn't, catch on to that. It was never presented in that way. It was just, Joe Alexander said the crime could have been committed in as little as 36 minutes. So
what was the defense attorney doing?
That's a really good question. He has signed a 19-page declaration stating all of the mistakes that he made along the way at trial. And he admitted at our evidentiary hearing that he didn't understand half of the laws that he was dealing with here. One of the defense's people who came up to the stand pleaded the 5th. And his trial lawyer just took that as a blanket statement and clearly did not understand the law that was surrounding pleading the 5th. and he never asked the person any follow-up questions. And he admitted at the evidentiary hearing that he just simply didn't understand. So he completely failed on his part to investigate any of these phone calls that placed Sean at home. Once the time was changed, 2 days after trial, he never objected to that time change. He never asked for continuance when he could have. He never said, I need to go and collect more evidence because you've completely swept the rug from under my feet 2 days after trial began. When he spent 10 months investigating the later time frame, he could have done any of those things, and he didn't. So he basically just sat back.
A lot of attorneys, unless they specialize in a felony murder case, they don't know all the ins and outs of it. I see a lot of attorneys advising their clients to go to trial when they're clearly going to lose, and they're not, they're not being encouraged to take a plea. This is one of the most horrendous laws on the books, and this is why. But I mean, in a death penalty case, they get specialized attorneys. Those attorneys have specialized training. In a felony murder case where they're not pursuing the death penalty, that's not necessarily the case. Did he have a court-appointed attorney or a PD?
No, he did not. He had an attorney that was hired, but he did not want this particular attorney. He did not approve of this particular attorney. He actually asked for a different attorney, but that did not happen. And he was 16 years old in adult court. He needed somebody to protect him as a child. He needed somebody who was going to take great care of a very delicate situation in which he was facing a maximum penalty. He needed somebody to really fight for him, and unfortunately, Clark failed him catastrophically. And later on, admitted to doing so, and admitted at our evidentiary hearing that he really was in over his head, didn't understand the laws that he was dealing with, and failed to object to a major discrepancy in the time of the actual murder. So
I know you've been waiting for the results of that evidentiary hearing for several years. If you win that, what happens then? Does he get granted a new trial, or is this overturned?
We're hoping to get a ruling. We've been waiting since January 2017. It depends on what the ruling says. It's possible that they could grant him a new trial. It's possible that he could have exoneration. It's possible that they could rule against him, but we just really don't know at this point, although he did completely prove his innocence at our evidentiary hearing. We have this thing called the Hoagland Report, and it's the prosecution's own evidence. It was an unrecorded interview with lead detective Tom Hoagland, prosecutor Joe Alexander, and Wellman's public defender Mark Ross. So the interview was completely unrecorded. It transpired on January 2nd, and that was before trial started, so it was 33 days before trial started. It was 10 days after Sean's alibi had been handed over to the prosecution. So Sean has a rock-solid alibi for the afternoon. He was at home with his friends, his sister, his niece. All these friends were coming over. He had a rock-solid alibi. They come to William Wellman in an unrecorded interview on January 2nd and told him there's a discrepancy with his time and got him to change the time of the murder from the afternoon from 11 to 1 to 9 to 11. So now he's saying it happened in the morning. And he stated that he stayed at Sean's house for 10 to 30 minutes before going to the gun shop, and he stayed for 30 to 40 minutes after committing the crime. So now you've just increased.
Know how to drive to Sean's house?
Right. So now you've just increased the time that he's been with Sean. And he also stated that he did not see Sean make any calls in his presence, that Sean did not have a cell phone. This was back in the days when cell phones were not super popular. They were not very affordable, so it wasn't unusual for a 16-year-old not to have a phone. But he did make that statement, so we can prove, yeah, Sean did not have a cell phone. He didn't make the calls in front of Wellman's presence. So there's no way that Wellman could have been around while Sean was making all these phone calls that morning.
Right.
And Wellman also stated that he saw guns being loaded into the display case at the gun shop. And they only do that in the morning. And at the evidentiary hearing, we had the employee from the Bighorn gun shop say, yes, We only load firearms into that display case first thing in the morning. We would never do that after opening. We would never do that with customers inside the shop. So they had to have been there right when the doors were opening, right at the opening at 10 a.m. So that places the gentleman who went to the Bighorn gun shop, went to the crime, committed this crime, there at 10 a.m., and we have proved that Sean was at home. So this Hogler report that I'm talking about, this unrecorded interview, wasn't presented until the second day of trial, and it rendered Sean's alibi completely irrelevant with this new time frame. But his trial lawyer, Clark, completely failed to object. He didn't say anything. He didn't ask for continuance. And had he objected, had he simply just said that he objected, later on it could have become a Brady violation, and it would have been appealed right away.
Right.
Because he failed to object. Go ahead.
That was why I was asking what this guy was doing. He obviously wasn't.
Right.
I mean, that's pretty basic. I mean, as far as attorneys and defense go, that's pretty basic.
Yeah, you change the entire time frame of the murder and you're not going to object to that. He stated at the evidentiary hearing that he didn't think that the judge at the time would sustain it. And that was his reasoning. So because he didn't think in his mind that the judge would sustain his objection, he just didn't object at all.
I mean, the crime was committed. These two kids a couple of days later finger Sean O'Brien. And my understanding was Sean was out of state by then. Did they go to the other state to question him?
Yes, that's when he was questioned by detectives. He had no idea what he was being questioned for. No Miranda rights were read. No attorney present. No parent present. No parental consent. And Sean had no idea what he was going to be asked about. So he said, sure, I'll talk to you. And he answered all their questions willingly. They came to his school in Oregon, and that's where he was questioned and interrogated for quite some time and asked about 17 different ways if he had participated in this crime. And he said no every single time. So at 16, without a parent, without an attorney, asked 16, 17 different ways, by these big prosecutors who had cornered him, basically. He was scared.
It's called the Reed technique. And it induces, a lot of times, it induces a false confession.
False confession, yeah.
It didn't. But
no.
I want to touch on that for a second, because in the intro, which you didn't hear because we were talking when it was playing, we talk about the go-around that police use for Miranda, and they call it voluntary witness statement. So a good attorney, and it sounds like Sean didn't have a good attorney, would have squashed that, would have said, he would have had that thrown out, anything that Sean said during that time. He had no attorney. He had no parent there with him. We're very familiar with that. Then you throw in the Reed technique and accusations and being asked the same question in a multitude of different manners. And they will say that they didn't read him Miranda rights because at that time they were just questioning him as a witness. So it is a voluntary witness statement, not necessary of Miranda. The problem is that if the individual does not feel free to leave, that is custodial questioning, and it does require Miranda. But they'll say that this was not custodial questioning and it was a voluntary statement. That's how they get around it. And they're very happy about it. And it sounds like that's exactly what they did here as well.
Well, luckily, Sean, he knew he was innocent. He stuck to his guns. He said, I have no idea what you guys are talking about. And he didn't say anything incriminating because he had no involvement in this crime. So, they got nothing out of him. They were very frustrated. They left, and eventually they extradited him back to California when this whole thing snowballed out of control. So basically, we have this alleged time gap that didn't even exist. We have Wellman changing the time of the crime, and then they, present it 2 days after trial. We have Clark's failure to object, and, had he just simply objected, we would not be here today. Had Wellman not changed the time of the crime, we would have Sean's rock-solid alibi. We would not be here today.
I understand that he thought maybe the judge would not sustain, but you don't know until you try, and there is no fault in trying that. I still am just blown away that they were able to produce new information or change of old information already into a trial, and a defense attorney not at the very least ask for a recess to be able to view the information.
He could have done anything, but he didn't.
16, most 16-year-olds are not.
No, he had no idea. He had no idea what was going on.
They aren't you going to object? I mean, they wouldn't know.
No, he had no idea what was going on. He says later he had no idea what was happening the entire time, pretty much at trial. It was all so overwhelming to him. He had been accused of something he didn't do. His family was in great distress at this time. He was in great distress, being placed in custody. And he had no idea what was happening. His lawyer did not explain it to him. And when the time change came up, he had no idea that it had even happened. They would not let him read the Hoagland report. They wouldn't let him read the discovery. So he was not entitled to any of the things that an adult going to trial usually does. So he pretty much just sat there and watched his life disappear.
Yes, unfortunately, that's exactly what happens in these cases, which is just horrible.
When he actually found out what happened, he was shocked.
So did they label him the shooter, or were they still saying that it was the other gentleman?
Yes, he was convicted. He was wrongfully convicted and sentenced to life in prison without parole plus 10 years for felony murder during a commission of a burglary and possession of a firearm. So Wellman was convicted of second-degree murder and sentenced to 15 to 25, I believe. And he's out on parole right now. So he got early parole. And Dixon is actually... we don't really know. It could have been Wellman. I personally suspect this other Sean Santilio guy. It could have been any three of them. It could have been Wellman, it could have been Dixon, or it could have been Sean Santilio. Any three of them, it wouldn't surprise me, but I really don't know. Nobody really knows. And unfortunately, no one will ever know because it will never be investigated. The only thing that they wanted to know was that they had a conviction on their hands.
Well, I don't know. I mean, guilt is a powerful motivator, and who knows, maybe one of these other boys eventually is going to realize that they've destroyed an innocent person's life, and they're going to come forward. I mean, we can only hope, but the first thing we hope for is that you're successful and that this is overturned. I mean, I don't see any reason to put somebody back through another trial if an evidentiary hearing has proven the facts in the case were not the facts that were presented in the original case, or at least that is what I would hope for Sean. Certainly, I've been following his story since Just Us put up that page, which has now been a few years. So what happened? I mean, he got convicted and they sent him away. Assumably, he's not near his family.
No, he is quite far. He spent most of his time in prison at Calipatria State Prison, which is actually near the Mexico border. So he was quite far from his family, and he still is. It takes a very long drive to get to him. And since his trial, the 3rd District Court was the first appeal that he went to, and they stated that they had overwhelming evidence. So they denied his appeal based on overwhelming evidence, quote unquote. And that's really solely based on just the testimony of these two men, one of which who was facing a death penalty. And so that really has stuck to his case. And so all of his appeals were denied. And the 3rd District Court also recognized the conflicting testimony that Petty gave about, dropping off the gun and also being at school at the same time, but they really did nothing about it. And then his habeas petition finally reached the 9th Circuit Court of Appeals, and that was in 2015. And the 9th Circuit Court actually ruled in his favor based on ineffective assistance of counsel. And would you like me to read the 9th Circuit Court ruling? It's kind of short. So the 9th Circuit Court ruling states, O'Brien's state habeas petition alleged facts that, if accepted as true, showed that trial counsel failed to introduce available evidence that would have significantly strengthened O'Brien's defense. Indeed, if believed, the additional evidence would have rendered it virtually impossible for O'Brien to have committed the murder with which he was charged, given the location of the murder and the state's theory as when it took place. They granted us an evidentiary hearing, and the evidentiary hearing took place in Federal District Court on January 2017. At this evidentiary hearing, we stipulated, which means everyone agreed, that the actual drive time was 47 minutes. So that's a really big deal. And we also had Wellman on the stand, and he testified that the only reason he ever changed the times wasn't because he had more time to think about it, which is what he had stated at trial, but that his trial lawyer had come to him and stated there was a discrepancy in his times. So basically, he perjured himself. And we have that on the record in the transcripts. And that's a really big deal also, because he originally had stated that the reason he changed the time was because he had more time to think about it. But now here he is saying that his lawyer came to him and basically told him to change the times. So we have perjury here. We proved his innocence, and we proved that he has these other phone calls. The Winslow phone call at 10:47 a.m. was never investigated by his trial lawyer. Sean had told him that he had called a man by the name of Winslow who worked at his mother's auto body shop at around 10:47 a.m., but wasn't quite sure what time he had called him. And his lawyer basically passed it off, thinking that the crime allegedly had happened in the afternoon, so it wasn't relevant. Well, when they came back and changed the time, he never thought, oh, I should investigate that Winslow phone call. And we had Winslow testify at the evidentiary hearing that indeed, if it had been asked of him, he could have come up with the exact time of the phone call by looking at the receipts that he was dealing with at the time he was dealing with customers in the shop when Sean had called. So we have the Winslow phone call at 10:47 a.m. that places Sean at home. And then we also have an 11:14 a.m. call to Mike Carrick, that's why Mike Carrick pled the fifth, because he didn't want to speak about something that he had done that didn't have anything to do with the case. But at the time, Clark had never questioned him further. So we have the 11:14 a.m. phone call, as well as the 10:47 a.m. phone call to throw into the mix. And so now we have, Sean at home all morning. And that's what we proved at the evidentiary hearing. But yet we don't have a ruling. So we're still waiting.
3 years?
Yeah, it's in June it'll be 3.5 years.
How long did it take to destroy his life? Matter of days?
Yes, he's been incarcerated for over 17 years. When he was 16, that's when he was arrested. And he'll be 34.
And are both of the other gentlemen out? I know you said one was.
One is, Wellman is out, and Dixon is still in custody. We don't know really anything about him or Wellman. We just know that Wellman was paroled.
So being as he is so far, are you able to visit?
Right now I can't visit because of COVID-19. They've shut down visiting. But before COVID-19, I was able to visit every, other month or so.
And his family?
They are not really involved very much in his life, unfortunately. He does a lot of letters with his grandfather, but his grandfather is unfortunately in such, frail condition that he can't really visit a whole lot. But he has a lot of letter correspondence with his grandfather, and some of his other family members are very supportive as well.
Yeah, we see that in so many cases. These guys, the fight becomes so long and so difficult that people just don't know what else to do. Families don't know what else to do, and they give up. And then it becomes very heartbreaking when they have that contact, not knowing what to say or not knowing what to do. And so many of these guys just basically get, forgotten.
Well, I think that the case and the trial really destroyed his family. They were pretty close before all of this happened. Sean was extremely close with his niece, and he hasn't seen his niece since she was 3 years old, and she's now 18 or 19, and he's just completely heartbroken over it. It really fractured his family, and unfortunately, in wrongful conviction cases, it feels like your child was stolen from you. So there's a lot of pain there in his family, and rightly so, because, he didn't do anything wrong, and he didn't deserve to spend 17 plus years in prison. And it's obvious in his actions, since then. And it's obvious with the evidence that we have that he's innocent, but he's really fought for his freedom. He's done everything that he possibly can. He's never had a 115. He's completely, disciplinary free. He's on the Men's Advisory Council. He serves as their chairman. He's 2 classes away from obtaining his associate's degree. He's a 4.0 college student. He takes every opportunity he can to better himself and to learn and to grow. And he takes his education really seriously. And he wants to continue that path when he comes home. He was accepted into Project Rebound, which is a program here at Sacramento University that helps the formerly incarcerated to get classes and to take classes and to, figure out what their educational goal is. So he's 2 classes away from his associates. So hopefully by the time he's out, he has his associates and he can get his bachelor's at Sacramento State University, which is excellent. And he really looks forward to that. And he's really driven to help others in his situation. He's an advocate for wrongful conviction, as am I, and he's an advocate for juvenile justice reform. He volunteers with Anti-Recidivism Coalition, Initiate Justice. He has a lot of meetings with other advocates, and he's also a mentor for other inmates, younger inmates, and he helps tutor inmates so that they can get their GED and better themselves. And so he has really, really worked hard to prove himself and to prove that he doesn't belong in prison. And it's clear to everyone who meets him. It's clear to the officers. They've written chronos about him, letters of recommendation. He's been recommended for resentencing by the California Department of Corrections. So he's come a long ways, and he's done everything he can every single day since his incarceration to come home. He's fighting for his life, and he knows it.
Absolutely, absolutely. And I'm glad that he has you to fight by his side. And from everything that I've heard here, I have no doubt that he will be able to come home and he will be able to take those classes and continue with what he's doing. And absolutely great that he's taken an interest in helping at-risk kids avoid getting into situations that they too could avoid, even though Sean unfortunately couldn't avoid anything.
If we could prevent this from happening to just one person, then we would consider it a success. Wrongful conviction has become such a hot topic lately, but it's been a passion of mine since realizing that that's what happened to Sean. And I spent a lot of time learning about it, researching it, and I would like to help him advocate for other people who have been wrongfully convicted. Once he comes home, that's what we would ultimately like to do, is to spend our lives dedicated to, stopping wrongful conviction and helping others who have been wrongfully convicted, especially juveniles, because this should not happen to anyone. No one should have to go through what he has gone through, and no one should have to go through what his family and I have gone through. We've experienced it, and we want to put a stop to it and prevent it from happening to anyone else. And if it's okay with you, I would like to read a quote from my favorite podcast, Court Junkie, about wrongful conviction.
Yes, absolutely.
It says, "Unfortunately, in wrongful conviction cases, there are literally no winners. Everybody loses. Not only is someone incarcerated at times for years upon years when they did nothing wrong, but the victims' families have to relive the pain of losing their loved ones over and over again, at the trials, at the hearings, at the appeals, the post-conviction hearings. It's a long, arduous process. And then, when a conviction is vacated, the families lose any hope of conclusion that they had in the case. They lose any sort of comfort they may have felt in thinking that justice had been at least served. And that's truly heartbreaking." Best way to sum it up.
It is, and unfortunately, most of the exonerations that we see are being done by the Innocence Project. Innocence Project focuses on DNA. Felony murder cases are not generally DNA cases, and right now,
correct,
reports estimating 120 to 150,000 innocent people incarcerated. In the freest country in the world, there's something seriously wrong with the justice system, and the felony murder law drives mass incarceration. It scoops up anybody that they can connect to any crime and scoops them all up with no regard for the role they played, no regard for if they played a role at all. It doesn't matter. It's absolutely, if you looked on our website and we showcased Ryan Hawley. Ryan Hawley, during a house party, loans his car to his roommate to go get food. Ryan goes to bed, goes to sleep. Well, his roommate goes out, commits a burglary, ends up with the girl dying during the commission of this crime. Ryan Hawley got life without the possibility of parole. He was home without sleep. There's something wrong with a law that can do this. And the prosecutor in that case admitted that Ryan Hawley was not there. Said, yes, he was home in bed asleep, but it doesn't matter. He loaned his car. No car, no crime. If they hadn't had a car, they wouldn't have been able to go there. They wouldn't have committed the crime. That is absolutely absurd. And in my opinion, without this statute, I don't think that they could have pulled Sean O'Brien in like they did. They can just go after anybody and everybody. Culpability is next to nothing. Mens rea is completely disregarded. And we can't afford to keep putting innocent lives in prison. We already have 2.3 million people in prison. That is 25% of the entire world's prison population. We only have 4.3% of the world's population to start with. So that's got to say something when we've incarcerated 25% of the entire world's prisoners. That's insane. And laws like this have to change. And the only way they'll ever change is when stories like Sean's are brought out and they're spread everywhere so people understand the horrendous nature of what our justice system has become. It's not about truth anymore. It's not about justice. And prosecutors have way too much power. And this particular statute shields itself from any type of judicial scrutiny. The judge literally, as you probably witnessed in Sean's case, is rendered, they're sidelined. They have nothing to say. They're basically a referee between a prosecutor and a defense attorney should they step out of line. And that's really it. They have no say. They can't control the sentencing. They can't control any of it.
I have to agree with you there because there was no DNA evidence or any physical evidence whatsoever in Sean's case linking him to the crime. So when we appealed to the Innocence Project, they turned us down because there is no physical evidence in Sean's crime. And so yet he was able, to be convicted with no physical evidence tying him to the crime based solely on just the testimony of two, criminals. There was no physical evidence. There was no DNA. So the Innocence Project has turned us down, and there's nothing that they can do for us.
Right. That's very common. It's unfortunate.
The burden of proof was very low here. They didn't have to prove anything other than a crime had taken place.
Right. Ultimately, all they needed to do was loosely connect Sean to a burglary based on the statements of these other two individuals, and that was it. They don't have to prove a murder. That's not necessary. Right. All they have to prove is that a crime was committed. It was felonious. It qualified to be enhanced to felony murder, and game over.
Unfortunately, in this case, that's what has happened.
Well, I hope that we can soon get an update saying that you've gotten a decision, and I really honestly pray that that decision is an overturn of the case. I don't see any reason why you should have to go back through a trial, but proving the points that were proven at an evidentiary hearing, I suspect would be enough to prove the same at a trial. It just would be a waste of judicial economy, first of all, and a lot more emotional upheaval for Sean, his family, you, everyone involved, and like you said, the victim's family.
Well, we've also applied for commutation, so hopefully that can get Sean home quicker than getting a ruling, because with COVID-19, the ruling process has been completely stalled. So right now, our best bet is to, have his sentence commuted either by the district attorney of El Dorado County or by Governor Newsom. And we've submitted his commutation packet for review. And when he does come home, if he is commuted, he can still wait for that ruling, and we can still work on his justice, for his exoneration once he is free. So we're really hoping that we can get his sentence commuted so that he can come home and just start working on, his life, going to school and working on getting his name cleared. But the main thing is that we just want him to finally come home. And we do have a petition up at moveon.org, and the link can be found on the Just Us story page. It can be found on our website. And we're just hoping that we can get his sentence commuted and that he can come home and start living the rest of his life.
Yes, when he does come home, we would like to talk to him.
That would be great. And he also wanted me to ask or to say that he appreciates everyone looking into the truth, and that all he asks is for people to look at the truth, and that he appreciates our time here on this podcast.
You can tell him from us that that's what we're dedicated to. You know my story, and I have a reason why this was brought to my attention. And even 6 years ago, if somebody had told me that this situation is what it is, I still wouldn't have believed it, even though it was happening in my own life. It wasn't until I started looking at other stories and realizing this is extremely common. This is unfortunately extremely common, and it needs to stop. So if we can get, like you said, one person, if anything we're saying here tonight reaches home for somebody, if this changes something for one person, that is successful. Obviously, we would want to get this story to more than that. So for our listeners, you are already familiar that Sean's story is on our website, and there is a link on our website that goes to the site maintained by Emelia and Sean, and that gives you a whole lot more detail and ways that you can help, and also the petition that Emelia just mentioned. So I ask that everyone listening to this, please take a minute, go sign the petition. Let's get this man home.
Please.
Do you have anything else you want to add for the listeners, Emelia? You've told us a lot, and I really appreciate it.
I think that about wraps it up. I mean, I haven't been able to hit on everything because there is just such a volume of information, details, evidence, but if anybody wants to find out more, like you said, they can access that information on our webpage. And this is just such a complicated case, but we just really appreciate you taking the time to talk to us tonight. And we just really appreciate that opportunity. So thank you.
You're very welcome, and thank you for taking the time to come on here and share what I know is really emotional. Every time you have to go through it, it just never fades. So for our listeners, if you have a story that you want to talk about, that you want to bring to our attention, felony murder cases, get in contact with us either via our webpage or through the Facebook page. The more stories that we can get out there to show how this law is being used and not for justice, the better off everyone will be. So I appreciate everyone listening tonight and joining us. Emelia, I thank you for coming on here and sharing your heart, and give Sean our best.
Oh, well, thank you so much.